Good afternoon, everyone. My name is Lluc Cerda. I'm a senior associate here at Samfiru, Tumarkin. I'm the managing associate of our Calgary, Alberta office, and I'm here today to take your questions regarding any employment rights questions you have, anything about employment law. We are here today to talk about your employment rights. If you have any questions, put them in the chat. I'm here for the next half hour, and I'll try to get to as many of them as possible today. And if I don't get to all of them, we have another show this coming Wednesday with Mr. Lluc Samfiru. We'll be taking your questions. So hopefully we can get to your question today. But if not, have no fear. We'll have more very experienced employment lawyers answering your questions throughout the week. I don't know if you've heard about this. There was a poll that came out by the Canadian Federation of Independent Businesses, and it showed that 76% of small business owners are thinking of either selling or closing down their small business in the next 10 years. So I see this a lot in the context of my work. People come to see me because their employer is selling their business or a new employer is buying their business. What does that mean for them as employees? So a few common things to look out for. So if an employer sells their business to a new employer, the main question a lot of people have is, what happens to my years of service? I've worked for the employer A for 10 years. Do I start out at employer B as a day one employee, or do I start out as a 10-year employee? All right, so something to keep in mind. That answer changes from province to province, believe it or not. But here in Alberta, unless your employer tells you, listen, your new employer tells you, listen, I'm not going to recognize your past years of service. Unless they tell you that, then it's presumed that they have recognized your past years of service. Okay, so look out for that in any offer letter you receive. Are they addressing your past years of service? If they don't address it at all, then you're in the clear. If they do address it and say, we're not going to recognize your past years of service, then you got to start thinking about whether you want to accept this new rule or not. Okay. Another thing to keep in mind when an owner is preparing to sell their business, they expect the buyer to do a lot of due diligence, and the due diligence the buyer is going to do, amongst other things, is look to see if there are enforceable employment agreement in place with the employees. So what I see a lot is that in the months to years preceding a sale, everyone gets new employment contracts. And these new employment contracts are not generally for your benefit. They're there to protect the employer, reduce how much severance you might be owed, make sure that there are clauses there that will be attractive to a buyer so they can take you on with minimal risk and exposure. So what you need to know about employment contracts that are presented to you midstream after you've started working, there isn't necessarily a requirement that you sign them, right? So you got to make sure that there's something in it for you. So if an employer tells you, listen, I want you to sign this new contract, I'm even going to give you a signing bonus. I'm going to give you a $300 signing bonus, or a $500 signing bonus, or even a $1,500 signing bonus. Be aware, as I was saying last time I was on, that you might be signing away your right to a lot more money by way of severance. Right, you get a $500 signing bonus, and you might be signing away tens of thousands of dollars of accumulated severance that you might be owed if you're terminated. So it is worthwhile to have us review your employment contract, let you know, explain to you what's in your contract, what you're giving up by signing the contract before you sign it, so that you can negotiate more advantageous terms for yourself. I see it all too often that people sign an employment contract and their 10 years or their 10 months or 24 months of severance gets reduced to 2 months or less, right? And so you want to basically make sure you're on top of that right at the start. There's also clauses that will say that they can move you away to any of their other locations, that you'll sign a non-competition agreement, all these kinds of things. Basically, if someone presents to you a contract that you had no hand in drafting, you can be pretty sure it's not to your benefit. All right. So it's very important you have that reviewed. Reach out to us. We'd be happy to speak to you, explain to you what your rights are, so that if there is that sale of business, that you're protected too. mean, you have some sweat equity in a business. If you've been there for a while, you need to be taken care of as well. So if that's the situation you're in, that you have been presented with a new employment contract, or that your employment has your business has been sold and now you're being asked to work for a new employer, reach out to us. We can talk to you a little bit about what your entitlements might be, what you might be able to get, so you have some sort of protection if things come to pass and you're terminated. So reach out to us. You have the website on the screen there, employmentlawyer.ca. All right. So we have our first question coming in today from JP on Reddit. Can I face consequences for not giving 2 weeks notice when resigning? My workplace has become very toxic and I am dealing with a lot of harassment and cannot go back. So generally, what employees don't realize is that there isn't always a requirement to provide 2 weeks notice. So here in Alberta, the Employment Standards Code says that you have to give 2 weeks notice. In Ontario, the Employment Standards Act doesn't say anything like that, right? So there's no requirement from that perspective to give 2 weeks of notice. When you're in a toxic work environment, that can amount to a constructive dismissal. All right. So a constructive dismissal is when, by their words or behavior, the employer has indicated that they don't want to continue to employ you, but they haven't come out and terminated you. So you can basically quit and say, well, you forced me to quit. You've created such an environment that I have to quit because it's damaging my mental health or whatever it is. In that case, not only do you not have to give notice, but you are probably entitled to severance. All right. So it's important that you reach out to us. We can get a bit more detail about what exactly is happening in this workplace, let you know whether it's safe to leave and whether you might actually be owed compensation. So feel free to reach out to us at employmentlawyer.ca. We'll be happy to speak to you about your rights. And you might be wondering, okay, well, so I might be entitled to severance. What are we talking about here? So we have a very nifty, I love talking about this calculator. We have a very nifty severance pay calculator at pocketemploymentlawyer.ca. Pocketemploymentlawyer.ca. You go in there, we'll ask you 4 basic questions, and we'll let you know what we think your severance entitlements might be, both in terms of how many months you're entitled to and based on your salary, what kind of money we're talking about, so that you have an idea of what your entitlements might be if you are in the situation that you're describing where it's impossible to continue to work because you're being so poorly treated at work. Feel free to reach out to us once you've seen what your entitlements are, and we'll be happy to talk to you about how to go after them. We have another question coming in here from Rosemary Krunkle. Rosemary. I work seasonally for a landscaping company. This year they have said they are reducing staff and not rehiring me for this year. Am I owed any severance? I worked with them for 7 years. So what I can tell you about seasonal workers is this, is if you're terminated at the end of the season and then hired back at the beginning of the new season, during that period between the seasons, you are not entitled to severance. But if there's a pattern of you being hired back every year, as has been the case here, you've been hired back for 7 years, and they tell you straight out you're not going to get hired back again, then you are entitled to severance. All right. So yes, basically being a seasonal worker doesn't mean that you're never entitled to severance. There will be times where you're entitled to severance if they tell you, we're just not going to hire you back. This is the end of the road for us. At that point, you're entitled to severance. So absolutely reach out to us and we can explain to you how to go after the severance that you're entitled to. And, I have your years of service here, but if you want to plug in the rest of the information on the Pocket Employment Lawyer calculator, then you'll have a better idea of exactly how much money we're talking about here. So definitely, it's worthwhile to check that out, see what you're owed. We have a question coming in from Darlene on Facebook. Can an employer make you sign a new contract for a shift change after working there for 10 years? So the reality is, Darlene, that they can ask you to sign a contract. No one can force you to sign a contract. But if you do sign the contract, then definitely any claim that you had that they couldn't change your shift is evaporated, of course, right? Because now you've explicitly agreed that your new shift is X, be it the night shift, the afternoon shift, whatever it is. I've seen a lot of people come to me and they say, Lluc, I've been working 10 years, as is your case, Darlene. I've been working, the 7 to 3 shift. Now, all of a sudden, they want to put me on night shift. What can we do? All right. And I tell them, well, if it's been 10 years, look at the contract that you signed when you started, if you signed one, and see if there was a clause in there that specified what your shift would be. If that's the case, then you can argue that you only took the job because of the shift, or that was a main reason why you took the job. Or put another way, you wouldn't have taken the job if you had been offered night shift. And so now that they're offering you night shift, you're not going to take the job, and you are going to treat your employment as being at an end. You're going to quit, and you're going to go after severance. All right. So you have to make that choice. Is this something I'm ready to quit my job about, or am I just going to, begrudgingly sign this contract and go on this new shift? If you sign and go on the new shift, then that's basically the end of the road. You're stuck with that shift. Okay. You can try it out. If it really, after 2 weeks or whatever, 2 weeks, a month, maybe you say, well, listen, this is not working for me at all. You might still have a case, but you can't come back to me 6 months to a year from now saying, well, listen, I signed this contract a year ago. It's not working out for me. Can I go after severance? By that point, it's way too late. All right. So you have a decision to make now. What do I want to do? Do I want to keep this job with the new shift, or do I want to go after the severance I'm owed for the 10 years I've been working here? And if you decide that you want to go after the severance you're owed, then definitely reach out to us. We'll be happy to speak with you. And if you want to get an idea, again, of what your severance entitlements might be, then you're looking at our Pocket Employment Lawyer severance pay calculator. You'll get a pretty good idea of what your entitlements might be. All right. We have another question coming in from Jean Smith, who asks, what sort of obligations can your employer enforce in a remote work arrangement? Can they make you turn on your camera or go to monthly staff lunches? So generally, when we get asked this kind of question, we, as lawyers, we frame it, is this an issue in the eyes of the law? So there are, again, parts of the country where this would be an issue in the eyes of the law. So, for instance, in Ontario, the Ontario government just recently passed a law on electronic monitoring of employees. All right. So the obligation is that if you're being electronically monitored by any means, that has to be disclosed to you. Doesn't mean it's not allowed. It just means that you are entitled to know about it. Okay. In the other provinces, in Alberta specifically, we don't have that kind of law in place. So there's not even an obligation to let you know that you're being surveilled. All right. So now what we have to ask ourselves is this fact that you're being surveilled, are you entitled to know? And if you do know, are you entitled to object to it? All right. And the way you would object to it is saying, well, this is fundamentally in contravention with the spirit of my employment conditions and my employment agreement. All right. But if it doesn't rise to a level where you can say, well, listen, this is just not something I think a reasonable person should accept, then the employer is entitled to put in, rules for the workplace. All right. So, for instance, the staff lunches. If you're being paid for the lunch hour that you're there, then they have entitlements to direct you to work where they want you to work, unless you have an employment agreement where he says, no, you're fully remote. We're not changing that. You're going to be fully remote from now on. And all of a sudden, you have to go into the office once a week or once a month or something like that. You can say, no, the deal is fully remote. This does not comply with that. So I'm not going to come in. You might face discipline, and then you have to decide whether you're willing to walk away from this job over this, right? And if you are willing to walk away from the job, you may be entitled to severance, but you first have to decide whether you're willing to walk away from the job. So it's a bit of a contextual analysis. I know my answer is probably not what you were hoping to hear, Jean. We have to look at it in the context of everything else. I personally think that being required to have your camera on at all times is too much. But I think that being required to go to a staff lunch once a month is probably not going to be in the eyes of the law too much. all right? Unless you really have something bulletproof in your employment agreement that says, you are fully work from home, you can't leave. Or unless you tell me, well, there's something about it that I can't do. I have childcare obligations, or I have a disability that affects my mobility or something like that. Then, of course, that's a different story. But if it's just a normal, we want everyone to have some FaceTime together, so there's a bit of camaraderie at the office. We'll pay you a lunch at a restaurant once a month. I have trouble seeing a judge saying, that's uncalled for. So that's definitely the way I think it would play out if you were to say, well, I'm not accepting this, I'm quitting, and I'm going after my severance package. The camera on at all times. I mean, there's rules in the unionized context, and that's generally not allowed. You can have cameras on in common areas like halls and cafeterias and stuff, but having a camera right on the employee as they work is usually not allowed in the unionized context. It hasn't really come to the attention of the courts all that much in the non-unionized context, but the time that it did, it amounted to a constructive dismissal. So definitely, employee monitoring has its limits. We have a question coming in from Art I have been recording my conversations with my boss for a few months now. My boss found out and he is threatening to fire me because of this. Can they terminate me with cause for doing this? So unfortunately, Art, there has been a recent case that came out in BC where this exact scenario had happened. And the employer had terminated the employee for cause for secretly recording his conversations with his coworkers and his boss, and the court found that was just cause for termination. Now, just cause is a contextual analysis. They're not just going to look at the incident. They're going to look at the context around the incident, why you were recording, what your concerns were at the office. But if you're just going in there and systematically recording everyone, that's a problem. I've had people tell me, well, listen, they tell me something, and then when I try to get it in writing, I can never get it in writing, and then they deny that they said it. So I started recording them for that. For instance, I had a woman tell me, my boss comes and yells at me, and then when I make a harassment complaint, they say, well, there's no documentary evidence. So I've started recording when my boss harasses me, yells at me, whatever it is. Honestly, I don't know what else you'd expect that woman to do, right? So I don't think that, in my personal view, would amount to just cause. But if you're systematically going into meetings, recording the meetings, if you're recording your meetings with your boss, and all of that, for no specific reason, you have no real concern, it's just something that you like doing, and you don't tell anyone that you're doing it, it could amount to just cause. So I'd be careful. Yeah, that case came out about a month or two ago, and basically there's been a lot more of that happening now where people are saying, listen, you recorded us, we're going to terminate you for cause. So do be careful, all right? And ask yourself, why am I doing this? I think that's an important consideration. As I explained to you in the harassment situation, that might be enough to explain why you were recording this, to document another violation of policy, which is the harassment policy. So I think that basically, if you're trying to document a violation of a policy, I don't think there's anything wrong with doing that through a recording, personally. We have another question coming in from Tony on YouTube. Can I sue my employer if they put me on an unpaid leave of absence because I had a seizure at work? So, no, Tony, I would tell you that would be a form of human rights discrimination. You're being discriminated against on the basis of your disability. Depends how they're framing it, but I want to keep in mind that this on its face looks like it's not all that legal. But I'm wondering if they put you on a leave of absence or on a medical leave. If it's on a medical leave, they would probably ask you for a doctor's note saying that you're cleared to return to work, that you can work safely in the work environment where you're employed. If that's the case, then I would say get that doctor's note. And if they continue to refuse to call you back to work, then I think you have a claim that you've been terminated, you've been constructively dismissed, and you're owed severance. All right. Not only severance, but potentially, if having this seizure had no impact on your job performance and your ability to do your job, then you're owed human rights damages as well, right? So there's a whole nother slew of opportunities that open up to you there. So that's definitely something I would say, reach out to us. We need to get a bit more detail of exactly what's happening. I find that odd that they would do that. I've seen crazier things happen, but there might be more to it that you might not have realized. So they might have asked you for a functional abilities form or something like that to make sure that you're able to work. But if really they're saying, well, unpaid leave of absence is generally for disciplinary reasons. If they're disciplining you for having a seizure, then that's not okay, for sure. We have a question coming in from Dela on Facebook. I recently asked my employer for a raise because of my on-call requirements. They've since become very hostile and are having me train junior staff on my duties. I'm worried if they're going to fire me. What should I do? Okay. So if they decide to fire you, they can't do it for cause, okay? So asking for a raise does not amount to just cause to terminate you, okay? They can still let you go, but then they would owe you severance, okay? So if you're owed severance, then no one is really required to continue to employ someone they don't want to employ anymore. They can terminate just about anyone for just about any reason, so long as the reason is not based on discrimination and is not based on retaliation for trying to enforce one of your employment rights. So asking for a raise is not covered by the anti-retaliation clauses. If you're kind of trying to enforce your right to take a medical leave of absence, a family leave, you're trying to enforce your right to be paid at least a minimum wage or to be paid your overtime pay or to pay your vacation pay, you can be terminated for asking for compliance with the employment standards legislation in the province where you work. They can terminate you theoretically for asking for a raise, just like they could terminate you for wearing a blue sweater to work. Really, nothing stops them from doing that. But then they can't say that that's because they have just cause. No, they have to pay you severance in that case, all right? So if you're looking at, well, what exactly does severance mean for me? I've said it a few times in the show. I'll say it again. You can visit our severance pay calculator, where if you answer 4 easy questions, we'll give you an estimate of what you think your severance entitlements might be. And so you can access that severance pay calculator right at pocketemploymentlawyer.ca. It's right there on the screen. If the workplace is hostile, you don't have to wait for them to terminate you. If it really becomes unbearable, as I was saying earlier in the show, you don't have to just become someone that goes to work to be abused, where your health is suffering and anything like that. You're having anxiety or panic attacks or depression. Speak to us. Tell us a little bit about what they're doing to make this so hard on you at work. We might be able to tell you, you know what, you're entitled to leave. Just quit and go after your severance pay. All right. Even though you've quit, you might still be entitled to severance pay. That's called a constructive dismissal. So Jean with a follow-up question. Jean was the one asking if she was required to attend workplace lunches because she works remotely, and whether she can be required to put her camera on at all times when she's working at her computer. So she follows up. Thank you. I work remotely 100% of the time, but I am quite far from where their office is located. It would take me all day to travel to and from a lunch gathering. Well, see, that's one of those things where I was mentioning. Yeah, if it doesn't really make sense, then you should be dispensed from it. At the very least, you should be paid for your travel time, right? So paid by the hour as well as gas, that should be on top of it. They hired you knowing how far you work from the office. So requiring you to go to the office for basically what seems to be a social gathering, they have to put their money where their mouth is, which is basically to pay you for your hours worked while you're driving there and your gas, right, for going there, right? I mean, if it's going to take all day to attend this lunch once a month, doesn't seem to me to make a lot of sense. I think this is one of those cases where you kind of have to start by explaining your point of view to the employer. Explain to them, listen, this is an all-day drive for me. Is there another way we can do this? Can we do the lunch remotely or something like that? Because this is way too far. I suspect, Gene, tell me if I'm wrong, that you were hired as a remote position, right? You've been remote ever since you've worked for them. It's not something that just came about when the pandemic happened. Or were you working from the office before the pandemic, started working remotely, and then moved further away? That could be another situation which might complicate things a little bit. But definitely, from this perspective, I would just kind of start out by just explaining to the employer, I'm full day's drive, from this office. Let's just see if I can be dispensed with this obligation. Now we have another question coming in from Tim. Tim is asking, I've been working in snow removal for the season. My employer has ended my contract 2 months early. Am I owed any sort of compensation for this? So a few things. So essentially, I would ask to see if you have an employment contract. So for a lot of seasonal workers, the contract will say you're being hired for the season, all right? And the season might mean, until the end of, I guess in this case, until the start of April. So you're expecting to work until the start of April. And if they terminate you midstream, if they terminate you 2 months early, then your severance entitlements would be what's left on the contract, all right, on the seasonal contract, which would be 2 months, all right. So yes, I do think you have entitlements. It might be up to 2 months, up until the end of your season here. So yeah, definitely. So, I've been telling everyone about, what kind of severance you're owed, and to go visit our Pocket Employment Lawyer severance pay calculator. When you're on a fixed term contract, it's a bit different. Your age, your years of service, all of that doesn't really matter. What you're going after is the balance of the contract. So if the contract is terminated early, there's 2 months or 6 months, there's 2 years left on the contract, you're going after the balance of the contract. All right. So definitely that could be a fair chunk of money. So I would say reach out to us. We need to see a little bit what you agreed to when you started working. But in my view, if your seasonal contract is terminated early, you're entitled to the balance of the contract. And you can reach out to us. We have the website on the screen here, employmentlawyer.ca. So Jean is following up. Jean is saying, I was hired as a remote worker during the pandemic. With things opening up, they've started to ask for changes. Yeah, so see how it is, right? I mean, basically, now that things are opening up, it starts, they want you to go to these lunches, continues, they want you back in the office, and all of a sudden it's like, well, I cannot drive, 3 hours each way to go to the office every day. So it's time you start pushing back. I would say you didn't work with them before. They knew where you lived when they hired you. They knew that was too far for you to drive on a normal commute. Tell them I cannot go to these lunches. If they start disciplining for it and you want to fight back, then you might start thinking, well, I would say requiring you to go to the lunches is not maybe enough, but if you say I cannot go, I will not go, and they discipline you for that, I think that's unfair discipline, and that would amount to a constructive dismissal. And so you can go after severance in that perspective. All right. So before we even go down that road of figuring out what the strategy is to get you your severance, you have to ask yourself, am I willing to walk away from this job if they follow through on this requirement that I start going to these lunches, which then might become that I go into the office once or twice a week, which might end up being full-time back at the office, right? Which in your case does not seem realistic at all. No one should be required to drive 3 hours each way to go to the office every day. So it starts becoming a bit of a slippery slope, and you kind of have to decide what you want to do at this point. And Jean also added, thanks so much. Well, it was my pleasure, Jean. It was my pleasure, all of you, for sitting in on this employment law Q&A. My name is Lluc Cerda. I'm a senior associate here at Samfiru Tumarkin. I'm also the managing associate of our Calgary office. If you have any Calgary-specific questions, feel free to reach out to me or anyone in my team, and we'll be happy to help you. Otherwise, if you have questions for other parts of the country that we operate in, we're also in BC and Ontario. We have Mr. Lluc Samfiru on Wednesday, who will be here to answer your questions, throughout the country as well. So tune in if you have any questions. We'll be happy to speak with you. That's at 1 p.m. live Eastern Standard Time. All right. Thanks for tuning in, and I'll see you soon.